So for those of you who haven't met me yet, my name is Emily, and I am the Adult Program Coordinator at Wisconsin's. And I'm sure that a lot of you are very familiar with the work that we do at Wisconsin's, but I do think that there might be a few of you who are here who maybe have a little bit less knowledge of us. And we are a nonprofit organization. We're based in the Fox Valley, but our reach is really statewide. And we're dedicated to helping siblings who have brothers and sisters with disabilities along their lifelong journey. So we offer a lot of programs from youth through adults. So for youth, we have SIB Sacks, we have SIB shops, a lot of summer programming, teen leadership. And this year, we're really working on expanding our programs to adults, which is what we're doing tonight, is offering you a virtual workshop with a guest tonight to talk about guardianship. And I do want to remind you that we're going to talk about guardianship from the lens of a SIB, since that's who we're in the business of serving. But the information will be useful regardless of your relationship to a person with a disability. And if you're interested in learning more about us, you can check us out on the internet. I'm going to drop our website in the chat so you can go there to learn more. I also do want to share some information about an exciting event that's coming up. So we are offering a Journey Forward workshop on March 16th in Oshkosh. This is a two-part workshop series that helps siblings and families start planning for the future. So during this workshop, we'll help you and your family identify some barriers that might be preventing the future planning process from happening within your family. You'll get some tools to create a plan of action, and you'll be able to prepare a letter of intent for your sibling with a disability. So if you're interested in joining that session, I will drop a link to either learn more or to register in the chat. Give me 1 second here. I've got a lot of screens open, but there's the link to learn more or to register if you are interested. I also want to put out a little teaser for an event that's coming up in March, and this is open to anyone. It's a pretty sweet event, and it's called Sibs Are My Peeps. And as you might guess from the pictures here, it's all about being creative with peeps. So I want to make sure that we have plenty of time to talk to Polly, so I'm not going to give you a lot of details, but keep an eye out on your inbox or on our website if you're interested in participating in this fun event. All right, so now to the main event that you've all joined us for. So please join me in welcoming our guest tonight, Attorney Polly Shoemaker. Polly is an attorney at the Guardianship Support Center at the Greater Wisconsin Agency on Aging Resources. So we're very grateful that she was able to join us tonight and share her wisdom with us about guardianship. Like I mentioned before, she's going to take some time to share some information, and hopefully we'll have time for some questions at the end. Again, we ask that you stay muted through the presentation and then use the raised hand feature during the Q&A session. So without further ado, I'm going to stop my screen share and turn it over to Polly.
Okay, I'll get my screen shared here too. Thank you for the introduction. I'm Attorney Polly Shoemaker. The Greater Wisconsin Agency on Aging Resources is an organization that's primarily funded through the Older Americans Act to provide information, resources, and assistance for adults over the age of 60. I am kind of a little special program within that. I get to work with anybody pretty much across the whole age spectrum, starting with transition age for teenagers. Who are moving into adulthood, and I get to talk about guardianship, powers of attorney, supported decision making. I have a helpline that's the bulk of what I do, where I answer questions about those things for anybody across the state or people who are outside of Wisconsin planning to move or planning to leave Wisconsin for somewhere else. Anything to do with decision making for adults, whether it's the individual making their own decisions or planning for the future, or family or friends wanting to know how to help their family members and protect their family members and loved ones. I have a free quarterly newsletter. I have a number of publications on my website. The main limitation that I have with my funding is that I cannot provide any court representation or legal advice. So if you do have questions about your own situation tonight, you may hear me say quite a bit. I can tell you what the law says and does not say. I cannot tell you what you should do with that information. If you call my helpline, you're going to hear that a lot too. So tonight, I'm going to talk a little bit about autonomy and self-determination, what that means for someone who isn't under guardianship but might need to be, and someone who is under guardianship in both of those scenarios. Some alternatives to guardianship if you have family members who don't have one yet, or who perhaps have one and would like to not have one, and may be at a point where that could be an option. We'll talk a little bit about the roles and duties of a guardian, and transition planning for standby and successor guardianship, the training program, what the future means for your loved ones, all those good things. So when we talk about the rights related to decision makers, these are things that apply across the entire spectrum of being able to make decisions. So even somebody who's under guardianship can make some of their own day-to-day decisions. We still have the rights to do some day-to-day choices, things that we do every day. We start from the position in Wisconsin that all adults are competent to make their own decisions unless and until a court says otherwise. I know we hit 18 and we don't magically flip a switch that makes us suddenly better and wiser at running our own lives than we were the day before. It certainly didn't happen for me. If it did for you, you're lucky. But I think for most of us, we hit 18 and we're just as good or not good at making decisions as we were the day before. But that's the marker that we have. And we assume that somebody who is over the age of 18 at least has some basic understanding of how to make their own decisions and run their life at least a little bit. And what that means when it comes to determining whether somebody needs a surrogate decision maker. Everybody has the right to choose and decline services, to decide how they want to live their life according to their own values and their own standards. And the decisions that people make may not be the ones that you would make, or that I would make, or that our parents would make. But if they have some basic understanding of the risks and consequences of what they're being asked to do, then they have the right to make those decisions. And when we're talking about the capacity for decision making, what that means is the ability to decide what to do in accordance with your own values, whether or not you can do that at a given point in time, whether or not you understand risk, and it can vary from one type of decision to another. Everyone's got the right to make at least some decisions. Everybody has the right to make some bad decisions. Those of us who, have never had a question in our mind about whether or not we would need a guardian at this point in our lives, if I'm a competent adult, nobody has ever suggested that I'm not. If I want to stay up till 2 o'clock in the morning, I'm probably going to regret it tomorrow, but I'm allowed to do that because I'm an adult. That's what we're talking about. It's the big decisions, but it's also the little things. Every time I decide, am I ready to get out of bed or not? Am I going to eat breakfast or not? Am I going to eat something healthy for breakfast or not? Little things, and then big things like, where do I want to go to school? Where do I want to go to work? What kinds of things do I want for my healthcare? What are my values around that? So we're looking at big decisions and little decisions all the time, and who gets to decide what for another person when it comes to that. When we talk about working with vulnerable adults, whether that's somebody with a developmental or intellectual disability, whether that's an older adult who is dealing with some form of dementia, whether that's somebody who's had a traumatic brain injury, or somebody who's in a mental health crisis, any and all of those kinds of situations. What we're talking about is the capacity for making a decision in a specific area, which means understanding risk. And that means, what can we see as far as harm goes? What is the nature of the harm that somebody could experience because of a decision that they've made? How likely is it that those consequences are going to happen? Are they willing to entertain other suggestions? Do they really understand what that possibility is? So for somebody who's a diabetic, for example, if they wake up in the morning and they think, my best decision today is going to be to have a bowl of Lucky Charms. Do they understand what the consequence of that is going to be? Do they recognize that that's going to potentially have an impact on their health and their blood sugar, and that could have some pretty major health consequences? If they get that and want to do it anyway, fine. But if they don't understand that, that's the point at which we start looking at, are there things that we can do to help this person learn better, understand better, make better decisions that don't put them in the hospital? Or are there areas where somebody else might need to step in because there's no way that we can help here? So what are the options in a given situation? What steps can we take to help keep someone safe? Can we help educate somebody to help keep them safe so that they don't need somebody else to step in? What's their prognosis? Do they have a condition that's expected to improve, or are they going to continue to decline? For something like Alzheimer's, it's probably going to continue, their capacity is going to continue to decline. But somebody who's had a stroke may continue to improve, or somebody who has a developmental or intellectual disability, they hit 18, their brains are still developing, they could get a little bit better at making decisions as they get older. So that's kind of what we're looking at. Where are they right now? Where are they going to be in the future? What are the possible harms? What can they understand about those things? What are they willing to do? What are they not willing to do? And what steps need to be taken to keep them from harm? When we talk about the spectrum of decision making here, we have everything from supported decision to substitute decision making. Supported decision making is a situation where the person is making their own decisions with whatever level of assistance that they would like. There's both formal processes for that and informal supports. Also, financial power of attorney, which is typically activated right away on signing, but doesn't have to be. And I know some of you, again, have family members who are already under guardianship, so this may or may not be super relevant for you, but for others who are looking at if guardianship continues to be necessary, or you have a family member who is getting to that point, reaching adulthood, and you're wondering what to do, this is some of kind of what we're looking at. So supported decision making, the individual is the decider, at least in the areas that they are able to, and they have their help. They have their helpers, their supporters, however they want to do that. Substitute decision making is where somebody else is stepping in and actually making that decision. So that's your healthcare power of attorney if activated on incapacity, financial power of attorney, representative payees, conservatorship, guardianship, those kinds of situations where somebody else is making the decisions. And in a lot of ways, what it really comes down to is who's in the room. I'm a big Hamilton fan, so I always have who's in the room where it happens going through my head when I get to this slide. Because when you're talking about substitute decision making, the person whose life we're making a decision about doesn't even have to be there. A lot of the time, they're not there. Somebody else could be making the decision just around them, not even there consulting them. So it's about who gets to be there, who gets to be at the table and part of the conversation when we're making decisions about a life. Formal supported decision making is something that came into law in 2018, so it's still relatively new. I've totally lost track of time with COVID. It feels like that was just like last year. It's not. It was now almost 6 years ago. Anyway, it's a law. It's formally in law now, and anybody can use it as long as they have a functional impairment that's self-attested. You don't have to have a doctor's note. Anybody who has any sort of struggle, functional impairment with activities of daily living, with communication, with mobility, any of those different kinds of things can use these agreements if they want one, if they want a helper to be there with them to help them in whatever kinds of tasks. So it could be with healthcare, it could be with finances, it could be help with vocational or educational issues, it could be assistance with housing. Any of those kinds of things can be covered under this agreement. The individual gets to choose who their helper is and what their helper can do. They're not bound by this agreement. They can decide, I want to make the decisions today. I don't want my helper with me. But it is a way for somebody to get that kind of help if they want it. It can also work in conjunction with power of attorney documents and with limited guardianship. So if you have somebody who, for example, really, really struggles with understanding complex healthcare needs, if they've got a really complex condition, they're really not going to be able to understand all of the ins and outs of that and what they're going to need in given situation. They might need a guardian or a power of attorney to handle that, but they could be able to handle making their own educational choices. Do they want to go on to college or community college? Do they want to do some vocational rehab? Do they want to do some other sort of job training or apprenticeship? That's the word, apprenticeship. That they could be able to do those kinds of things if they have some help and they're allowed to have their helper. So it's a way to kind of help somebody fill in the gaps. And it can work, again, not only with people with developmental disabilities, but also pretty much anybody who's got an issue that they want some help with. I often use one of my really close friends as an example for this. Um, I have her permission to do that, which is good because, this is being recorded and might end up on YouTube. I have her permission. She gets really bad migraines and she also has really bad anxiety. And especially when those two things are coming together, she loses words. She has really bad aphasia. She is not able to express what's going on. She's not able to function, at least in some ways. So having somebody who can be her voice when she's at the doctor, when she's at the ER is really, really important. And this is something that she would be able to use if she lived in Wisconsin. She doesn't, but if she ever does move up here, we're going to put one of these together. I'm her supporter. I'm her auth rep to deal with her student loans. I've been her person in the ER. That I'm there to be her voice when she's not able to be it for herself. She's perfectly capable of making her own decisions. She just has a really hard time getting the words out sometimes. We also have a lot of informal supports that are out there. One of the issues that tends to come up with supported decision making is that you have to be 18 to start one of these agreements. And of course, if you're not sure whether your soon to be 18-year-old family member is going to need a guardian or not, then the question is, do we try this and see what happens? And then if it doesn't work, now we have a gap in decision making. Or do we just bypass it and decide it's not going to work and go into guardianship? And I think there are ways, of course, to engage our family members in decision making as teenagers. I'm sure many of you are familiar with that. Many of you may have done that when you were teenagers. I'm pretty sure I was running most of my own healthcare when I was a teenager. I was getting some help from family with financial things into college after 18. So there's a lot of things that we can do formally and informally, both of those things to help people learn how to make decisions better. For me with finances, the main thing was that when I went off to college, I had a credit card that my parents were paying the bill for, but there was a very strict rule on it because they were paying the bill. I could only use it for plane tickets home or textbooks. Or like a real emergency situation. I couldn't use it for anything else. And if I did, without asking permission, they would stop paying the bill. I mean, I could if I asked first, but if I didn't ask first, then they would stop paying the bill. It happened exactly once because I was trying to reach them and I couldn't get a hold of them. And it was something that I knew they would have approved, but I didn't ask first. And under the circumstances, they were willing to kind of let it go and be like, all right, we'll go ahead and continue to pay this because we know you tried to ask us. But it was something that they took pretty seriously, and so did I. And I think in a lot of ways that really helped me learn to not be careless with somebody else's money. Because I couldn't just go out and use it and run up a big bill on it and not have to face any consequences for that because it wasn't my money that was be paying for it. So there's things like that you can do to help somebody learn how to manage money better. There's things like TrueLink accounts and Able accounts that can be really limited to only specific areas. TrueLink is one of those programs where you can set up exactly which kinds of categories of spending and limits on those. There's other programs like that. That's just the one that I know the best. But other things like that, ways to help somebody learn how to manage money if they've been struggling with that or could use some assistance with that. Even somebody who's under guardianship can use some of these tools to learn how to better manage their own money, perhaps with an eye towards someday being able to do it all on their own. So let's talk a little bit about power of attorney documents, because this comes up, I think, a lot for family members of soon-to-be 18-year-olds who want to know if this is an option. We divide power of attorney into healthcare and finances. To be valid, a healthcare requires 2 disinterested witnesses. Financial should be notarized. These have to be created by the individual. I think the number one question I get about powers of attorney is, how do I get power of attorney over my loved one? Or my son or daughter is about to be 18 and I'd like to get power of attorney to make a decision for them. How do I do that? And the short answer is always that you can't. They have to give it to you. It has to be voluntary. From the decision to create it to who they choose as the agent and what the agent can do, all of that has to be driven by the individual. These don't remove rights from the person. Most of the time, if it's activated on incapacity, it's just a determination that this kind of decision wouldn't be enforceable if the person were to sign it on their own. So for medical, it's that they're not capable of informed consent right now. If it's a financial is activated on incapacity, they're not capable of signing a contract right now. It wouldn't be enforceable if they did. So when it comes to finances in particular, I think what people struggle with is this idea that I can just get power of attorney for finances and I will be able to stop my loved one for falling for scams. I will be able to stop them from just draining their bank account to give all of their money to the next person who offers to take them to Burger King for a milkshake. I had a family member use that example once, so it's stuck in my head. I will be able to stop them from misusing their funds, and you really can't, because it doesn't remove their ability to access their money. All it does is make it so that you can help them with those things. You can help pay the bills if they're not able to do that. You can help do the things that they're not able to do, but it doesn't stop them from being able to get to their money themselves. So whether or not that's the appropriate step really depends a lot on whether the person is willing to do it and what their needs actually are. So for healthcare, as I mentioned, it's typically activated on incapacity. It is possible to have it be activated right away on signing so that the person can have their agent make decisions for them right away. It's not very common in Wisconsin, and it really tends to confuse healthcare providers. The question is always who gets to sign releases and consents. That's what a POA is about for healthcare. Who gets to sign a consent form? Who gets to sign a release of information? So yes, it's certainly possible to do it that way. It has to be specifically written into the form because the state form doesn't contemplate that as an option, but it can be done. For at least some folks, supported decision-making is going to be a better option. If they want somebody to help them right away because they're overwhelmed, they're confused, they need somebody to help them understand, supported decision-making is perfect for that. If they're at a point where they really can't make their own healthcare decisions, they're not capable of understanding, then having it be activated immediately is fine. Or if they just don't want to, having it be activated immediately is fine. Both those situations are fine. Or somebody who has a lot of variable incapacity. So that tends to come up with people who are in later life, who are dealing with dementia or some sort of progressive disease where they know that their periods of incapacity are going to be increasing. They don't want to have to deal with activating, deactivating. So those are both potentially options. Again, the person has to be of sound mind, which means that if they are already under guardianship, this is not an option for them. We assume that somebody who has a guardian appointed cannot create a power of attorney. But for people who are willing to create them and who are able to make at least some of their own decisions or want to turn over all decision making right away, they can work really, really well. It's just really important to know that it has to come from that individual. And if somebody is, you've got somebody in the situation where they'll sign anything that you put in front of them without looking at it, I would not call that willing and totally voluntary and without coercion because they don't know what they're signing. They're not paying attention. The key here is, do you know what you're doing when you sign this form? If you ask somebody, what does this do? Can they explain it to you? And if they can't, they shouldn't be signing this document. So let's talk a little bit about incapacity as a legal concept when it comes to healthcare and finances in particular. It is, the definition, the inability to receive and evaluate information or communicate decisions. It is a point in time determination. So for a healthcare or financial power of attorney, when that document is activated on incapacity, we are asking healthcare providers to assess this person and determine how are they at making decisions right now. It is only a determination of how they are at making decisions right now. We assume it's probably going to continue for a while, otherwise we wouldn't activate it necessarily. But we're looking at whether or not that person can understand what they're being asked to do at this particular point in time. And incapacity for one thing does not necessarily mean incapacity for other things. So again, somebody might have really bad brain fog from meds. They could make other kinds of decisions. It depends on what they're being asked to do and what they're being asked to understand. For somebody who has these documents in place, if an agent is acting for a healthcare or financial power of attorney, generally the standard is that you follow that person's wishes where they're known or as expressed at any time. And if you don't know what the person's wishes are, you act in their best interest. So that's both a pro and a con of a power of attorney document for the individual. The pro of it is that your agent has to do what you want them to do. The con of it is that your agent has to do what you want them to do. So that if you need something and you're not willing to do it, whatever it might be, they can't override you And that's sometimes really, really bad. If you have a need that's really urgent and you can't understand or make the decision for yourself, and you are refusing to do care or get care, they can't override it with a POA. So that's important to know if this is an option or people want to try them, that is the limitation. For somebody who has a guardian or a conservator, the standard is best interest. So, very brief history of guardianship. And just a note, because I forgot to put in a slide about conservatorship, what that means in Wisconsin. A lot of states use that term differently. If you're familiar with Britney Spears' case, California refers to all adult guardianships as conservatorships. It means something totally different here. So here, a conservatorship is essentially a voluntary form of guardianship of the estate. So somebody who is unable or unwilling to manage their finances can ask the court to appoint a conservator for them. They get to choose who that is. That conservator has the same authority that the guardian of the estate would, and the same court oversight and reporting. It's just a way for somebody to say, hey, I want this, but I'd like to have some more oversight of it. And there's a number of different ways to go about it. The key to it is that there's no finding of incompetency or anything like that, and the person can ask the court to end it at any time. It's up to the court's discretion. If they don't think the person's capable of managing their money, they don't have to, but you can always ask. And it's a whole lot easier to undo that than it is to undo a guardianship. So, brief history of guardianship. Wisconsin used to have what's called plenary guardianship. And plenary guardianship is what we usually mean when we use the term full guardianship, wherein the guardian gets authority for pretty much everything except any rights that the court may have specifically left to the individual. Guardianship of a minor is almost always plenary guardianship. The guardian is given the authority to do anything and everything to make sure that that person is cared for. For an adult, in states that have it, and when we used to have it, it was the same thing. Guardian can do pretty much anything and everything for that person, has authority to make all different kinds of decisions, except anything that the court might have specifically left to that person. And they often didn't. We had limited guardianship. It was not often used, and it was not really well understood, so it was pretty rare. Most of the time, if you had a guardianship put in place, it was a plenary guardianship. That changed in 2006. The law was passed that created the new Chapter 54 at the end of 2006 and implemented into 2007, and totally eliminated plenary guardianship. We don't have it at all anymore in Wisconsin. There are people who have cases going back to before that time who may still have those orders. Some of you may have siblings who've been under guardianship since before that time who may still have those plenary guardianship orders. And those guardians have a whole lot more authority than a guardian would under an order implemented now, because we now have it very specific. The way we have it now is that the court specifies what authority the guardian has, and the person retains everything else. So it's exactly flipped away from the way it used to be, where the guardian had everything except the court left the person. Now the guardian only has what the court says, and the person has everything that's left. So if you do have family members who are under those old orders, they're fine to stay as they are. But if the individual could make some of their own decisions at this point and wants to, then it might be worth considering updating that at some point. Up to you, up to them, up to the court. So why would you do guardianship then if we've got all these alternatives? We talked about it a little bit already with POAs. If the person's unable or unwilling to complete a POA document, if those documents don't provide enough authority, I think the really big example for a lot of the people that I work with tends to be with older adults who need long-term care. If they have checked the box no on the form, because we require that you give your agent authority specifically to admit you for long-term care for a nursing home or community-based residential facility. If you check the box no, your agent can still admit you for post-inpatient rehab, but they can't admit you for anything else. And for people who now are at a point where they might need long-term care, if they check that box no, they're not able to admit themselves, their agent can't do anything. Their agent can't admit them. Even if they're sitting here saying, well, I'd be okay with it, if they can't create a new POA and check that box yes, they're out of luck. You'd have to go to court and get the court to do that. So that's one example. Another one being where somebody needs some kind of a decision to be made, but they're refusing. Or you just need more authority than you have under these documents to do something. then generally it would be a situation where the person meets the definition of incompetency and is at a risk of harm if there is no decision maker appointed for them. I have a slide coming up on what exactly incompetency was, but I'm going to talk a little bit more about what guardianship is and is not before I get to that point. So guardianship as a concept is a means to make sure that somebody's daily needs are met. Do they need healthcare? Get those healthcare decisions made. Do they need housing? Get that housing done. Do they need somebody to help manage their money because there's no way they're going to be able to do it on their own? Make sure those things get done. That's what it's for. It is a court process. It takes rights away from somebody. It's generally going to be permanent. So if you have a family member who was put under guardianship at 18, that's probably going to last the rest of their life. It doesn't have to necessarily, but it's pretty difficult to undo. We don't have any sort of time limited or like short-term guardianship. We have a temporary, which lasts for up to 120 days, but that's it. Like Minnesota has a new law where they have to have a review at least every 72 months if the guardianship starts before age 30. Nobody knows how it's working yet. It's been in place for 3.5 years, so we haven't hit 72 months for any of those orders yet. We'll see how it goes. I'm kind of waiting to see what happens with all that. The intent there was to make sure that if somebody is put under guardianship at 18, that it continues to be appropriate for them when they hit 25, when they hit 30. We don't have that sort of a review here. The person can always ask, the guardian can always ask, but at this point, generally speaking, unless the court believes that that person has regained their decision-making capability, that guardianship is going to continue, and it's difficult to undo. So if you have family members who don't have a guardian yet, it's important to know that this is the option of last resort. It's very, very hard to undo, but it also is something to know that if you have family members who are already under guardianship, it can be modified to be less restrictive, and it is possible to undo. It's difficult, but it has been done. It can be done. One way that the courts will sometimes do it and sometimes allow it is if the person has or is willing to put into place supported decision-making and or power of attorney documents. Britney Spears, again, for example, because she's really famous and her case was in the news so much, when her conservatorship ended, one of the pieces of that, one of the court's requirements was that she have supported decision-making set up because she hadn't made any of her own decisions in 13 years. She hadn't managed her own money in 13 years. She hadn't managed her own healthcare in a really long time. And so to suddenly throw all of that at her in a situation where she hadn't had any ability to do anything or have any say in her life at all, pretty overwhelming, I think, for her for sure. And for a lot of other people, it would be too. So she has some supported decision-making agreements set up, or she did when the court case ended, to make sure that she would have some help easing back into that and learning how to do all of those things again. And that's certainly something that can be done here as well. Guardianship is not. And I have this conversation a lot with parents of soon-to-be 18-year-olds. So as siblings of young adults of any age, when you're talking with your family about what's appropriate, when you are looking at possibly taking over a guardianship from your parents or whoever else might have it right now, it's important to know that it is the ability to make decisions to keep somebody under a roof and have food and healthcare and all those things, but it's not an extension of parenthood. And that's, I think, a really hard thing for a lot of parents of 18-year-olds, where, you've been this person's sole decision maker or one of a very few decision makers for a lot of their life. And the things that you can do for a minor are very different from the things that you can do for an adult. And it's a hard transition, but you have a duty as a guardian to make sure that this person's best interest is met. And that's not always the same as your duty as their family member. And I think it's very important for people to realize that and know exactly what guardianship means when they're getting ready to get into it. It's a conversation I've had with my own parents as well, who hopefully will never need guardians. But if my mom ever does, I can't be her guardian because I need to be her daughter. I can't be that person who's taking her rights away from her. For you, with your family members who may already be under guardianship, they may prefer to have it be somebody that they know and trust is going to be there for them. My mom was kind of upset about it, but when I explained that it's not because I don't love you or want to be there for you, I want to be there for you, but I want to not be the person who is doing things you don't want me to do for you. And I think she understands that. So hopefully it's not ever an issue. But for me, that's kind of where I could do it for my dad, because he wouldn't be fighting with me constantly. My mom would be, and that's the part of it that I don't want to have to deal with. So it always depends. Whether or not you should be the next guardian is going to depend on your relationship with your loved one, whether or not you are willing to take on the responsibility that it entails, and to know that the decisions that you're going to make are not always going to be what they want you to do. And you need to know that when you get into this. So it is not the chance to make every single decision for somebody. It is a chance to make the big decisions. So a guardian doesn't necessarily get to decide what time they get out of bed in the morning, what they're going to wear today, how they do their hair today, every meal that they have, what they get to listen to for music, who they get to talk to on the phone, at least some of the time. But a guardian can say, here's the supports that we're going to get in place for you. Here's what your big picture of your life is going to look like. Here's how we're going to make sure that all of your needs are met. It's not a way to change behavior. And I talk to family members about that a lot as well. I had somebody call once who was very worried that their soon to be 18-year-old was going to hop on a bus and travel to Oregon. She'd met some guy on the internet who wanted to buy her a ticket. I'm sitting here like, okay, you get guardianship of her. How are you going to stop her from doing that? If he buys her a ticket, he emails her that ticket, unless you're checking her email constantly for her and you get that before she can get to it, you can't actually stop that. If somebody gives her the money to get a bus ticket on her own, she can still do that and she can still go. And you can't actually stop her because you're not her jailer, you're her guardian. And I think it's important to understand that you're not setting out to change how somebody is. You're there to help make sure their needs are met and meet them where they are. It's also not a way to force mental health treatment. And I think this is a really important thing for people to know too. It's one of the big limitations on guardianship in Wisconsin. Here, a guardian cannot involuntarily admit somebody for mental health treatment, and cannot involuntarily consent, cannot consent to involuntary medication. So if somebody is objecting to psychotropic meds, a guardian cannot force that for them. If somebody needs to go to inpatient psych to stabilize, or because they're in crisis and doesn't want to go, guardian cannot force that. You still have to go through the court proceedings for that. It is possible for somebody who is under guardianship to self-admit to psych if they're willing, but if they're not, you can't force it. And I think it's really important that you know that as well, because for some of you and your family, that is going to be a concern if it hasn't been already. So when we talk about guardianship and what the standard is, the person has to have an impairment of some kind. That impairment has to result in incapacity. So somebody who has physical disabilities but is still capable of making their own decisions is not going to meet this standard. That incapacity has to get them to the point where they're unable to meet their essential needs for health and safety, meaning those actions necessary to provide for healthcare, food, shelter, etc., without which they will be seriously harmed or have serious illness, something like that, and also unable to provide for their own support or prevent financial exploitation. So the kid who will give all of the money to the person who takes them to Burger King for a milkshake is somebody who probably cannot prevent financial exploitation for themselves and may be at a point where a guardian is necessary to help prevent that. And the key then is that there's no less restrictive alternative. So could supported decision-making work? Could a power of attorney work? Maybe, maybe not. The court's supposed to look at that and decide if those are options. Only a court gets to decide if this is the case for somebody. As a court process, the first thing the court does is appoint a guardian ad litem, independent attorney whose role is to represent the best interest of that individual. They have the right to counsel. They have the right to attend the hearing if they want to be there. The court has to tailor that order to meet their needs. Now, in practice, often what actually happens is that the provider who does the evaluation for the court will check all of the boxes for a full transfer. The court will check all of the boxes for a full transfer. The individual will still have some rights left to them, but in practice, that order doesn't get tailored nearly the way it was intended when we did this change in the law. The court records are all confidential, so you can't just walk down to the courthouse and ask to see somebody's court file or their order. If you need to know if somebody's under guardianship, they can confirm whether or not they are and provide the information for the guardian if you have a need for that information. If the guardian is appointed, the court issues a determination and order outlining its findings and then letters of guardianship. And the letters of guardianship are the documents that the guardians use to show what authority they have. So they give that to the doctor, they give that to the bank, whoever else, in order to be able to exercise their authority for the ward. General duties and powers, only the authority that's given to you. Act with care, diligence, good faith, attempt to ascertain what that person wants, advocate for their best interest, advocate for their rights. Guardianship of the person typically is going to be all of the healthcare needs, the other kinds of daily living issues. So medical decisions, whether or not somebody can get a driver's license, a hunting or fishing license, whether somebody can get married, whether they can get divorced, whether they can consent to donate organs in the future or consent to sterilization if that's something that they want, decisions about education, work, all those kinds of things, travel, are all under guardian of the person. Guardian of the estate is all of the money pieces. So managing that person's finances, making sure that their bills get paid, making sure that their money is spent on their best interest. Depending on where you are, some decisions do require court approval and there are some spending limits. The decisions that require court approval are set out in statute, but the spending limits aren't, and that varies a lot from county to county. So if you are looking at the possibility of becoming your sibling's guardian of the estate in the future, it might be worth having a conversation with the register and probate about what that means. What are their limits? What are their policies? Like some counties, the limit is $500, aside from things like regular payments like rent and mortgage, that kind of thing. Any other extraordinary things, if you're going to spend more than $500 in those counties, you have to ask first and get that court approval first. Other counties, it's anywhere from $100 to $1,200 or $1,500. So it varies a lot from county to county. And it can change depending on who's in charge in the county. So it's important to, when you take over, find out what those limits and rules are. If you're in Outagamie, they have the strictest rules in the state. Just be aware of that. But every county's got its own rules. So know what those are and know what you need to get permission for before you can do it. When we talk about making decisions, what we ask for is that decisions be made in the least restrictive way. And really commonly, I mean, it's a lot of words. You know, what does that actually mean? It means making sure that we respect that person's rights and wishes where we can. So if somebody wants to be able to make day-to-day decisions for from themselves and is generally able to do that, then that's what we let them do. You know, what we're doing here is risk management. A guardian can restrict some rights and some exercises of those rights if it's necessary to protect that person. So the really common one that I hear a lot about is communication and visitation. People retain the right to free association, spend time with people of their choice. The right to decide who they get to spend time with belongs to the person, not to their family. So if you have somebody, for example, whose parents are divorced and one parent says, no, the ward gets to come with me this weekend, that's not their call to make. It's up to that individual to decide, do I want to go to mom or dad's this weekend, or do I want to stay where I am? I'm doing fine here, thank you, I don't want to go. That's their choice to make. It's not up to their parent. If they want to spend time with their friends, they're allowed to do that. If they want to call people, they're allowed to do that. Again, if there is a concern about health or safety, a guardian absolutely can restrict that if needed. So, for example, if you have somebody who wants to spend time with people who have historically gotten them in trouble with the law or have gotten them, helped provoke them into getting into fights or causing property damage, or if you have a family member who has had AODA concerns in the past and the first thing they do is go find their friends who have provided them with substances, yes, a guardian can restrict that and can limit that, because you don't want that person to get in trouble with the law if it's avoidable. You don't want that person to get involved with using substances that have put them at risk and at harm in the past. But other than that, a lot of the time it's really up to that individual and to do and communicate with the people that they want to communicate with. Again, health or safety, absolutely, you can limit that. But it's their choice if they don't want to spend time with somebody too. So if they have somebody they don't want to see, that's their call to make too. Things like intimate relationships. A lot of people assume that the fact that somebody is under guardianship means they're not capable of consent. That's not true. They often are and do want to be involved in relationships, romantic relationships, physical relationships, those kinds of things. Sometimes they want to have children, and that's okay too. They're allowed to decide that if they're capable of deciding that. The Disability Rights Wisconsin has a lot of really good resources on safety planning and talking about physical and romantic relationships with people with disabilities, intellectual disabilities, and developmental disabilities in particular, about understanding what it means to be in those kinds of relationships and what the consequences are. So I think there's a lot of really good resources there. I would encourage folks to check those out. Things like alcohol and smoking. Again, can somebody be safe? Maybe it's not necessarily the best plan for them to smoke, but if they can do it without setting everything on fire, that's, fine. They're allowed to do that if they have some place where they can go. But if you have somebody who, through negligence or because they forgot they had something burning or because they just like to see things burn, has a tendency to set things on fire, perhaps you need to have some supervision or not allow them to smoke. Things like how they spend their own money. Again, if it's something like illegal substances, then you can limit that, but otherwise you need to kind of let them do what they want. If they want to go spend their $45 or their $100 pocket money at Dollar Tree, they're allowed to do that. That's fine. Maybe that's not what I would do with mine, but who am I to judge? I mean, again, to go back to my really close friend, she doesn't have a guardian. She's her own decision maker. But when it comes down to personal spending, she makes choices that I would not. Do I need the next Sharknado movie? No, I don't. But am I going to judge her for it? Yes, I am a little bit. But she's allowed to add if she wants. It's fine. So let's talk about future planning. I guess I'm keeping an eye on the clock here, and I want to make sure I have a little bit of time for questions. So you have a sibling whose parents have been the guardians for this period of time since they turned 18, and now the parents are considering what happens when we're not able to do it anymore, or perhaps they're at a point where they're no longer able to do it. What happens next? Standby guardians can be added during the initial petition process, but they can also be added later. There's specific court forms for that. We have a document on our website as well about what that process looks like and what the forms typically are if they're needed. A standby guardian can step up either temporarily. So if the current primary guardian needs to deal with their own health issue or they want to go on vacation and they're not going to be accessible, a standby guardian can step up for that period of time. And then whenever the primary guardian is ready to come back, they come back. Cool, everything's all good. The standby goes back to being on the list. They're on call for whenever they're needed again. If the current guardian becomes incapacitated or chooses to step down because they're no longer able to do it, then the standby can step up permanently and they'll get their forms that say, here I'm the guardian, I get to make these decisions. There's a form to notify the court, mail that in or take it to the court, and they will issue new letters of guardianship naming that standby. If it's a temporary period of time, they'll give the dates if they're known. If it's permanently, they'll say that too. If there's no standby on the list, but now a new guardian is needed, it is possible to petition to be named the successor. So, if you have a parent who is currently the guardian and some horrible thing happens and now they're incapacitated or they passed away and there's nobody willing to step up or nobody on the list to step up, you can petition to be named successor guardian. Some counties will require a hearing for that. Not all counties will. So it's a good idea just to check with the probate office and find out, do you need a hearing for this? Some will only have a hearing if people object, if anybody objects. So kind of a good idea to just check in ahead of time. How do you handle this? Just so we know, or go ahead and get added to the standby list now, and then you don't have to worry about it down the road. So guardian training. This started to be required last year. It's a program that's done through UW Green Bay. It's online, it's free, it's available at any time. I am not part of UW Green Bay, but I was at least a little bit involved in the implementation of it. I was consulted on the content. So there's a lot of questions about this, and there will continue to be questions about it, in part because of how the law was implemented, because nobody who implemented the law actually does this work in the court system at all, or really knew what to expect. Among those questions, it is not known whether and when standby guardians need to take it. As far as I know, the consensus around the counties has been that people who were added as standbys, who are on that standby list before January 1st, 2023, don't need to take the training because you're already on the list. You've already been approved. But if you are going to petition to be added as a standby after that point, you probably do. The question then is, if you take it and you fill out your form and everything when you're first appointed as standby, but then you're not appointed for 15 years, do you have to take it again? And I don't know, because nobody else seems to know, because we're not going to know how this actually plays out, I think, for a while. I think if you are in that position, I think it's a good idea to review it anyway, because things change. And with any luck, they'll have kept it up to date in terms of what's going on in the law, what changes might have come into place since you were first on this list. Some counties do have their own initial and ongoing training in addition to the UW Green Bay course. Most of the time, standbys don't need to do that unless and until you're actually stepping up. But if you want to, you can always talk to that county and see what they do and if there are things that you want to take in that point. Again, if you were already on that standby list before January 1st of last year, you don't need to take it, but you can if you want to, and it's probably a good idea whenever the time comes for you to step up, just so you know, again, what are all the requirements that I'm going to have to fulfill here. So just a couple of other notes, and then I'll get to questions. If you're at a point where parents are starting to think about stepping down or want to start to include you in decisions with the intention that you'll become the next guardian, they can sign releases of information so that you can start talking to providers, to the bank, whoever else, to start getting some of that information, seeing the records. They can include you in that decision making. Social Security rep payee process is totally separate from guardianship and can be done at any time. So if you have a guardian who is still willing to handle the medical decisions, but they want to start handing over the finances, you can do that. You can apply to be that rep payee at whatever point they and you are ready to do that. I think the big question that comes up for a lot of folks, though, is the wards living situation. So if you have somebody who's still living with parents, and that has been the plan the whole time, but now parents are getting to a point where they might need assisted living or they're ready to downsize, where's that ward going to go? Are they going to live with you? They're not required to. If you're the new guardian, they're not required to, but you can do that if that's the right choice for you and for them. Or are they going to live in something like a group home or some other kind of a facility? What does that look like? Where is it? What are their needs? What is the structure of that facility? How much supervision? When we talk about least restrictive, it's not just the type of facility, but it's also the other access and things around it. So if the person has a job, has friends, has a community, wants to be able to access religious services near them, if those are things that they've been involved in, making sure they can still do that is important when you're looking at where they'll live. If you have somebody who really struggles with noise and light, but wants to be close to things, what accommodations can you do to help them with that? If you have somebody who needs more distance from people who have been harmful to them, or they would rather be in a quiet place, rather have some distance from a city, then that might be more appropriate too. So it's about what that person needs and what their preferences are, and making sure that when you are working with case managers or others who are helping identify living situations, those are the things to keep in mind. So if somebody's on family care and the MCO is saying, no, we're just going to put them here because it's the first next one on our list, you need to talk to them and figure out, is this really the right option? Is it 3 counties away from everybody they've ever known? Maybe that's not the right choice. Or if they have had a lot of concerns with people that they've been spending time with who have been harmful or have caused them to cause harm to other people, maybe that is the better option. So what do they need? What do they want? And your role is to make sure that those things are there to the extent you possibly can and make sure their needs are met. So, we're almost out of time. I tend to ramble a little bit. I'm happy to answer any questions that folks have, and you can always reach out on the helpline or access the resources on the website as well.
Thank you, Polly. And if you all haven't looked in the chat, I do have the website and the toll-free helpline in there. If you want to ask a question confidentially, you can send me a direct, like a private chat through the chat box, and I will read that out without naming you. Otherwise, if you have a question and you want to just ask it quick, you want to use the raise your hand feature, we'll get things going. Oh, I have a question already. Okay. Okay, so is there anyone that can help you fill out the guardianship paperwork for court? We can pay for a guardian ad litem, but can't afford a lawyer for us as parents.
That's a really good question. It depends a little bit on where you are. Milwaukee has a couple of options. The Children's Hospital has a clinic for kids who are patients at Children's. I don't believe it's available if your loved one is not a patient at Children's, but that is an option if they are. The Marquette Law School Volunteer Legal Clinic can also help with those forms sometimes. Beyond that, there really aren't a whole lot of resources. If family or if you have a kiddo who is, or a family member who is likely to qualify for Medicaid, sometimes the county can help. It depends a lot on the county and their own policies. They often prefer that family do that if they possibly can. You can always ask me. Again, I'm limited to, I can tell you what the questions are getting at. I can't tell you how to answer them, but we can certainly talk through it. It will take me a while to get back to you because it is just me and the Guardianship Support Center, and I get a lot of questions, but I will certainly do everything I can to provide as much information as I can. We can talk about, like, should you have a guardian of the estate or not? Should the person, what kinds of decisions can they make? Do they want to make? How to approach the rest of the form, and what does it mean? I just can't tell you how you should specifically fill it out.
Yeah. Hi, Polly. I have so many questions, but I'll try to reel them in. So I guess, okay, so I adopted my grandson when he was, I think it finally went in through when he was 2. So up till then, I was his guardian. Now I'm legally his mom. I have done all the paperwork for Katie Beckett already because he was on the wait list. So he's already been cleared for that for when he gets to be 18 or whatever. But he's on Medicaid now. But anyway, so I was told that there's only a short window to apply for guardianship, like between 17 and a half and 18.
So you can file as soon as 17 and 9 months. You can file at 17 and 9 months. And the court, once you file the paperwork, the court hearing has to be completed within 90 days. So that's why that's the soonest that you can do, 17 and 9 months. If it goes,
and he has to be agreeable, does he have to be agreeable to that as well, or?
No. I think there are a lot of kids who don't want to be put under guardianship, and if that's what they need, then that's what they need. Again, it's a pretty drastic option, but for some kids, it's absolutely what is necessary. He does not have to agree with it, but if he wants to contest it, he can then. So if he says, I don't need a guardian, I want the chance to make my own decisions, he can ask for that hearing to be contested, and it may be a fight. So just prepare for that and know that that's a thing.
And thank you for that question, Amy. I do want to be mindful of everyone's time. So thank you again, Polly, for joining us tonight.
Thank you.
I did put all of the contact information for Polly in the Guardianship Support Center in the chat. So be sure to grab that. You have the toll-free number. You can check out their website, and there's also an email there. So if you have additional questions, feel free to connect with Polly there. Polly, thank you again for joining us tonight. We really appreciate your time and your wisdom.
Yes, thank you so much.
Yeah, and thank you to everyone who joined us on the Zoom call. We appreciate it. Keep an eye out for future events. And if you have any requests for things that we can do for adult siblings, please be sure to let us know. Otherwise, thank you all and have a great night.